rule, Candace?
That at that point it became bonds.
So once a non-merchant, keyword there is non-merchant, makes a tender, then the risk of loss passes. So that being the case, I think Brandon, what's the answer here?
A.
A. Candace, you agree?
Yes.
Okay. Question number 4. I guess the question here, tell me, Ann, what's going on here?
Should the non-conforming goes and the paragraph reject the name.
So, see me, who's in error here?
Place.
So therefore, who should suffer the burden of the loss?
Place.
So the answer is D. And you agree? So Cindy, that kind of I think Cindy, there's a danger that we get too caught up in the FOB and all those terms, and we miss the point here is the one that made the mistake was Lane, Lace, because he shipped the wrong goods. Therefore, he bears the loss. Question 5. So, Matt, we have a contract to purchase 50 lamps from Globe Manufacturing. Strikes me that, Matt, that's a good name for a manufacturing firm that manufactures lamps. Bill prepaid 40% of the purchase price. Globe becoming insolvent on September 19 before segregating. So let me ask you this, Matt. Let me give you this fact, and let me give you this fact, and let me give you this fact. A 40% prepayment, a insolvency, or a before segregating. And Matt, what does that mean?
Okay, so before segregating, like they took it out before,
To segregate in this term means to do what? To set it aside?
yeah. No, they took it out before, like the contract was full.
So it doesn't mean to set aside, so what does it mean?
They took it out.
Which means to set it aside,
Yeah.
to ship it to the buyer. So Megan, we got three terms here. A prepayment, insolvency, and a segregation. Which do you think is the most important term?
Segregation.
Segregation. Therefore, Megan, the answer is
C.
B.
I mean B.
Okay. Very good. Matt, you agree?
Yes.
Okay. Question number 6. Kelsey. Kelsey, well, let me read the question. We maintain a warehouse where it stored its manufacturing goods. We received an order from Star shortly after they identified the goods. Kelsey, to say identified the goods, is that to say the same thing as Matt just said about segregation? That is, to segregate and to identify the goods mean the same thing? The reason, but before moving them to the loading dock, authority store the warehouse and its contents. So therefore, something bad happened, but it happened when, Bijou? After segregation, after identification, which means, Bijou, the answer is C. Kelsey, you agree?
Yes.
In fact, I think, Kelsey, we can eliminate A and D because those make no sense. How can you, to have title means you have ownership, and how can you have ownership but not be able to buy insurance? I mean, that makes no sense. Obviously, if I own it, I can buy insurance on it. So we could have eliminated A and D to begin with, and then the answer must be B and C. Question 7. AJ and Michael. Michael, continue with the theme of an insurer interest. the earliest time a purchaser of existing goods, and Michael, I think this is just a definitional question. So AJ, I apologize for making it too easy. Two things, I won't do that all the time. AJ, the answer is the earliest time that and Michael, to have an insurable interest simply means in plain language, I can take out insurance. So AJ, the earliest time that I would have an insurable interest is D. Yes. As soon as the goods are identified in the contract.
I think what
Michael,
just
you want-
confused me was like the last, like, when I answered in the homework, I got it, but compared it to the last question, when you say that the purchaser, like, got possession, it made me think, it kind of confused me with A. You understand what I'm saying?
I think so, but the question is, what is the earliest time that I can buy insurance? And so the earliest time I can buy insurance, not necessarily when I'm entitled, but the earliest time I can buy, not necessarily when I have ownership, but the earliest time I can buy insurance is if, so let me think about that. AJ, why would I wanna, you be the insurance company, and I'm gonna come to you and I'm gonna ask you to buy insurance. Why would I need insurance if I don't have possession? Why do I need insurance if I don't have ownership and I don't have possession yet? Because I have a contract with Michael, and today we have a contract for me to sell widgets that you will manufacture 6 months from now and ship me 7 months from now. So I don't have possession, they don't even exist yet. So what is that to insure? Well, let's suppose that I have a contract with Linda, and the contract with Linda is, what am I gonna do for you, Linda? There you go. What am I gonna do? We're gonna enter into a contract, and you are a property developer, and I'm gonna build 100 homes. And to build 100 homes, I need your widgets. I don't know what widgets are, but go with me. So therefore, AJ, I need insurance, because if he does not deliver the widgets to me, then she is going to sue me for breach of contract. So I need insurance to protect myself against her lawsuit, and trust me, she'll be vicious.
Oh.
Michael, does that make sense? Because you might think, well, again, if I don't have possession, if I don't have ownership, what is it to insure? Well, I'm insuring myself against Linda's lawsuit because I can't fulfill her contract. Which AJ might be a good time to talk about in the later notes for today. We'll talk about the impracticality defense. And somebody tell me what the impracticality defense is. So I have a contract. Let's suppose I have a contract. Let's suppose Michael has a contract with me to deliver widgets to me. And let's suppose, Michael, that your employees go on strike. So what's the problem? The problem, Brandon, is if his employees go on strike, he can't make the widgets, he can't honor the contract. And so I sue him for breach of contract. And AJ, you hope that I'm successful in the breach of contract, because if I'm successful to get a remedy from him, I won't go after the insurance company. So you're on my side in this. To protect me from Linda's lawsuit, and she's going to be vicious. So Michael, your defense is impossible. I cannot produce the widgets because my employees are on strike. So tell me, those of you who've read ahead in the notes of today, tell me, anybody, tell me how good his defense is, and tell me what so somebody tell me. In fact, Candace, I'll make you the judge, all right? And you tell me if it's a good defense. Somebody tell me what the standard is. Somebody know? Oh, hello, Angela. Anyone volunteer?
Kind of all lost in your story.
I'm sorry?
I kind of got lost in your story.
Okay. Here's the story. Here's the story. I have a contract with you to give me widgets. that you're gonna manufacture, and your employees go on strike. So you argue you are not in breach of contract because it's impossible to honor the contract because his employees are on strike. My question is, you got the facts now? So my question is, and he's making the impossibility and practicality defense, what do you think the standard should be? Yes?
I would say it doesn't have to be like unforeseeable.
The question is, Megan, is that what you're gonna say?
It's like commercial impact.
The question is, was it foreseeable that what happened could happen? Was it foreseeable? So let me make sure I understand this. I have a contract with Michael to sell me widgets. He's unable to deliver, which really annoys Linda because I can't build the houses. And you know you can't have a house without a widget. And so your defense is my employees went on strike. And Alex, before I ask the judge what she thinks, Megan and Katie have told me the law. The law is he would be excused from performance if the event was unforeseeable. Knowing, Alex, the way that he treats his employees, is it foreseeable that they might go on strike? Now, Candace, what if you did not know that he's got bad history? Is it foreseeable? Is it foreseeable, Candace, that a manufacturing firm may suffer a strike that would hurt the deliveries? And also, think about this. Think about this. Katie, as a matter of law, one of us should lose. Either I'm going to lose, or he's going to lose. And it's unfortunate that there are losers, but this is life. There will be losers. Who is most responsible for the circumstance? Is it me for dealing with him? Or is it him because his employees go on strike?
Yeah.
So it would seem like Megan and Katie that the impossibility and practicality defense is probably one that would seldom work. You agree? Because anything, for example, what if it was we were in Florida and your manufacturing facility is destroyed in a hurricane? Is that foreseeable? In Florida? So can you come up with an example of something that was not foreseeable?
Keith Harrison burning down your business.
No, I think that's very foreseeable. So arson, I think is, what do you think, Candace? I think arson is
I would think foreseeable.
foreseeable. It's not necessarily probable, but it's certainly not beyond the realm of possibility. And of course, when you add Keith Harrison, it's like, oh, he's in a smoking time bomb. So let's do this. Brandon, when we get to that part in the notes later on about this, be thinking of it in your subconscious mind, and we'll see if we can come up with an example where that defense would work, because Candace, in the majority of time, it would not work. And I think, Candace, from a policy standpoint, I think that seems appropriate because somebody's going to lose. It ought to be the one who's most responsible. And certainly not me. And of course, Linda, who I have the contract with to build the houses, she is saying, what are you saying? Hey man, that's your problem. Okay, so, question number 8. So again, a basic definitional question. Greg, which of the following statements applies to sale and approval? And tell me, Greg, what a sale and approval is.
When the
Talk to Angela.
when the buyer says that they will, accept it.
So is it kind of, in a sense, Greg, a conditional sale, a conditional sale? So I sell to you and you have X days to approve it, and so therefore the sale is not final. Kelsey, you should never ask a question you don't know the answer to, but it just occurred to me. How would that, from a financial accounting standpoint, when would the sale be booked? Do we know? A bunch of accountants. Let me restate the question. So you have a sale and approval, and so when is the sale, when is revenue recognized? Somebody know? Well, yeah, when earned. But Alex, that's another way to restate the question. The revenue is recognized when it's earned.
But is it not technically earned until they accept it?
Well, I don't know. That's the argument. That is
That
because
would make sense.
if the person has the right of rejection,
Yeah.
then arguably the sale's not final, and therefore not earned until, I don't know. Somebody has to flip that question. Okay, so Alex, which of the following statements applies to sale approval? Now that Greg has told us what it is, then it's simply a matter of applying the relevant law, and Alex, the relevant law would say the answer is C. Greg, you agree?
Absolutely.
Therefore, the risk of loss passes to the buyer, when the buyer says, I accept. Which Kelsey would suggest that from a gap standpoint, I don't know why I'm worried about that. Why am I thinking about that? Kelsey? Kelsey, why am I thinking about that? Okay. And Michael, you still have my clicker. He's not here. So, I don't know what happened to you. And you were the one complaining, so I'm sure. Okay, so the questions for today, also I should note that our first exam is a week from today. So today we'll talk about performance and breach of contract and remedies. Then on Monday we'll have a guest lecturer who will talk to us about warranties. And then on Wednesday we'll do a review of everything we've done so far, and then Friday we'll come back and have a test. So, seller must transfer and deliver conforming goods. Keyword is conforming. Buyer must accept and pay for the conforming goods. In the absence of an agreement, in fact, I think you should highlight this. Everything that we're going to say about the UCC provides for this, UCC provides for that, UCC provides for the other, is always in the absence of agreement. The UCC provides the following. The UCC good faith provision, good faith means honesty in fact, and it's a standard imposed on everybody by the UCC, interestingly enough, not by the common law. Contract performance for a merchant, it means honesty in fact and observance of what's reasonable in a commercial standards. And merchants are held to a higher standard because they have more knowledge. Good faith in contract performance, seller's obligation is to transfer and deliver conforming goods. Buyer's obligation is to accept and pay for the goods. Court imposes a good faith standard when contract is unclear. So therefore, if contract does not specify a delivery date, then Kelsey, the court will say the delivery date is whatever is reasonable. Tender delivery occurs when seller makes the conforming goods available to the buyer. That is, you can get them. Requires reasonable notice, reasonable hour, and a reasonable manner. So, Kelsey, if I call you at 2 o'clock in the morning and say, come pick up your goods, that's not reasonable. Generally, all goods are shipped in one installment unless agreed upon by the parties, but in a sense, Taylor, I probably don't need to say this unless agreed to by the parties, because that, I probably don't need to say it here, or maybe, Taylor, I should say it every time. That makes sense? That is, anything you and I agree to can overcome, so this is only when the UCC, or when the contract does not tell me what to do. Place of delivery. Again, Michael, when the contract does not tell me what to do. Parties can agree goods tendered at a particular destination for buyer to take possession. If the contract does not specify, then the place is the seller's place of business or the location of the goods. And I think that makes sense. Buyer picks up at seller's place of business, or if buyer has no place of business, then the buyer's residence. Both parties know the goods are elsewhere, that is in a warehouse, or perhaps in another state, or perhaps with a third party, place the deliveries where the goods are. And I think that makes sense. Shipment being a carrier, and we talked about last time about the shipment contracts. We talked last time about destination contracts. The perfect tender rule, and again, tell me, Megan, tender means to make available. The perfect tender rule, if goods or tender delivery fail in any respect to conform to the contract, the buyer has the right to accept the goods, reject the entire shipment, or accept part and reject part. So therefore, Linda, you ship me goods which are not exactly what I asked for. Why would I accept the goods?
If you just don't really care that much about it.
And so maybe it's not a material difference, or maybe it's not worth the time, or whatever. Or maybe Michael, I've had a 10-year relationship with her, a commercial relationship with her, and she's got enough goodwill built up to where we'll let it slide. But the point here, Linda, is that it's,
Not material.
well, and it's also my option. And again, I could reject the entire shipment or accept and reject. An exception again, Taylor, is by agreement of the parties that we might agree what to do when the goods are non-conforming. Cure, what does cure mean? To fix. The seller has the right to repair or replace defective good within the time of contract performance. So Linda, you ship me non-conforming goods. Before I sue you, I've got to give you an opportunity to fix the problem. So I say, these goods are not up to the standard that I want, and you say, oh, okay, give me some time and I'll fix it. And then I give you 6 months and you don't fix it, so then what do I do?
Then you can sue.
Then I take it to court. Reasonable grounds required for a cure. Seller's reasonable grounds to believe that buyer will accept non-conforming tender. And Linda, that might be the case if you and I have been dealing for years and I always look a blind eye when it's the wrong color. Because if you think about that, Michael, if I'm going to put your widgets in Kobe's house, and let's suppose it's part of the plumbing, nobody's going to see what color it is, so it's non-conforming goods, but it's not material. There's a limitation of right to reject goods, substantially restricts rights of rejection. Buyer must act in good faith and give specific reason for refusing acceptance. So Linda, I can't just simply say, I don't like them. I have to give you a reason. Now, Brandon, we come to commercial and practicability. We talked about it earlier. Give me an example. So Michael's example where his employees go on strike, or Megan's example where Keith Harrison commits arson, or the other example of the hurricane. Can you think of a case, a situation where that would work?
Terrorist attack?
Yes, suppose. Is it foreseeable? Let's go back 14 years. Is it for 15 years? Is it foreseeable that if you have an office in the 30th floor of the World Trade Center, that somebody would fly a plane into it? Now maybe today that's foreseeable. I would argue in the year 2000 it was not. And would you think, Kobe, that after the events of 9/11, do you think there would be a ton of lawsuits? And in the majority of cases, the defense worked because unlike your strike, or your hurricanes, or your arson, flying airplanes in the World Trade Center, I mean, you'd think, if you're on the 30th floor of the World Trade Center, you'd think that normal operation should continue. Also, just suppose, Kobe, let's suppose that there was a CPA firm that had an office there. Think of how much damage would be caused to their business. Think about that. All the records are lost, all the computers are lost, everything, of course now they've been cloud, but then, and so would a lot of contracts would have failed. And Brandon, again, in the majority of cases, this defense worked in those cases. Do you think, Kobe, so Angela, let the record reflect, Kobe gets a gold star because he's a terrorist. Do you think, Kobe, that it's more foreseeable today?
Yes.
Yeah, what do you think a court would do? I don't know. And that's when we have juries to decide these things. Okay. Let's talk about the Mabel case as another example of commercial impracticability. Alex, send me the facts of this case.
So Maple Farms made a contract with the school district for a full school year period, or for 2 years, to sell them milk at a fixed price. And then, unfortunately, the price of milk rose, and then they
Went
were
up like 23%.
yeah, and they were losing money then with the contracts, so they tried to get out of it because it was a fixed price, and the school district took them to court.
So I think, David, that's a good summary of the facts of the case. We have a contract between a school district and a farm, and to deliver it was a requirements contract to deliver all the milk. And then it became, I think, from the school board's point of view, I would say, if I was them, I would say, you mean it's inconvenient to you to deliver the milk simply because the price came up and went up? And then they said, well, we can't deliver, we're losing money at this. And also, do you think, Alex, if they lose this case, if the farmers lose the case, do you think it would have a ripple effect on every other contract that they had? So, Alex, what did the court, so therefore, Alex's defense was impracticality.
Right.
Similar to Michael's union, or let me see, I think, who the hurricane? Well, that was Sydney. And then Megan had the arson. What did the court do?
They sided with the school district and said it was foreseeable that the prices would rise.
And I think that is foreseeable. But then as a matter of strategy, I think it probably would be easier for them to pay for damages than deliver the milk. But then, think about this. David, and certainly wasn't the farmer's fault that prices went up, or the middleman's fault the prices went up. But And then I think in terms of, Alex, in terms of sympathetic clients, nobody's more sympathetic than school children. Maybe farmers. And so neither party is at fault, but which party is in the better position to absorb the loss? Arguably, it's the commercial vendor. So, Alex, was the court right?
Yeah.
Okay. Exception to the perfect tender rule, in practicality, we've done that. Destruction of the identified goods, if no fault of either party and occurs before risk is passes to the buyer, then both are excused. But, so I think, Michael, in your case, maybe you should just burn the bridges. Just burn down the factory. And then that would get back at the employees who were in the strike. Okay. So we talked about obligations of the seller, now obligations of the buyer. Obviously, the buyer has an obligation to make payment, unless agreed to otherwise, and Taylor, there's that exception. Payment is made when the goods are delivered, but that would only be the case, Taylor, when the contract does not say otherwise. And Taylor, would you think most of the time the contract would say otherwise? would think so. Credit has to be prearranged, payment with cash, credit card, or check. Buyer has the right of inspection. Goods must be conforming before payment. Again, absent an agreement. Acceptance, buyer can accept goods by word or conduct. Give me an example, Megan, of accepting goods by conduct.
Using it?
Using it, very good. Exactly. If buyer had reasonable amount of time and failed to reject, Megan, you have used it, or maybe you haven't used it. Maybe you just put it in your warehouse for future use, but 4 months have passed. Is it reasonable to assume that you've accepted? Buyer performs an act which indicates he thinks he is the owner. Take control, possession. Partial acceptance. If some of the goods do not conform to the contract and seller has failed to cure, buyer can make a partial acceptance, which I think makes sense. Anticipatory repudiation occurs when a party communicates intention he will not perform. So therefore that means, David, I don't have to wait until actual breach. I can actually do something when I have notice that you will breach. So here's an example. Delaney agrees with Linda in January 2015 to sing at her wedding in June 2016. In March 2015, Delaney informs Linda that she will not sing at her wedding because you do not believe in marriage. And so it must be another Delaney. So, Linda, what are your options? And then, so tell me the things that you can do, and then Megan, tell me what her damages would be. So, what can you do? Do you have to say, Dawn, and then wait to June 2016? In fact, you've been told today, you've been told in March that she wanted to sing at the wedding. So, what would you do?
Find a replacement?
Find a replacement? And can you start looking for a replacement now?
Yes.
So what if you sign a contract with, who's a good person to sing at a wedding? Angela. So you sign a contract with Angela to sing at the wedding. And what if Talini comes back in June and says, I've changed my mind, I now believe in marriage. Are you still bound to her?
No.
No, because she told you she's not going to do it, and you have a new contract.
If she hadn't found Angela though, and I came back and I said I wanted to.
Ah, that's a good question. What if, that's a good question. First of all, let me ask, what's the legal answer? And then secondly, let me ask, what's the practical answer? So the question is, what if she had not found Angela and you changed your mind? So you said, no, I'm not going to do it. And then later you said, okay, I will. What's the legal answer?
She just made an offer.
Ah, very good. So you choose made an offer for a new contract. So what happened to the old contract?
It's gone.
It's gone. So therefore, legally, she can say no because you breached it. Now, as a practical matter,
I'd hire her again.
you're too easy. Okay. And could you commence a lawsuit against her?
Yes.
Yes. When? Today.
Yeah.
Okay. Now that I thought about that, I think one of the principles, Megan, is that when we have a lawsuit, we have to have damages. And so, what would the damages be? And frankly, Linda, you're just angry. Can we get damages for that? No, people get angry all the time. So where's the harm? How is Linda in a worse position?
She has to pay a lawyer now and another singer. That might cost her money.
Okay, so therefore, yes, Sybil, how much were you going to do it for? $1,000. How much are you going to do it for, Angela? $1,200.
Okay.
So Megan, what's the damage?
200.
200. Now, yes, suppose that she also has to pay, let's suppose she also has to pay Megan a finder's fee to find Angela. And what's your finder's fee?
$700.
Okay. So can we add that to the damages?
Yeah.
What if you found Angela on Craigslist? Can we now add the damages?
No,
Why not?
it's publicly reported.
Because if you could find her on Craigslist, so could Linda. As a practical matter, Taylor, let's change the facts. Let's suppose that the anticipatory repudiation happened in, the wedding is June the 3rd? Is that right? When's the wedding?
June 18th.
June 18th, and the breach occurred on June the 16th. Now, Megan, what does that do?
Makes it a lot harder to find.
Makes it a lot harder, and Angela, what does that do to you? That means you can ask for more, and Talini, what does that do for you? That means you're even worse of a scumbag than you were before, but that means that the damages would be greater because it's more difficult to find. But I think, for our purposes, this is an interesting discussion. The main thing to think to take away from this is that the non-breaching party may suspend performance and treat the anticipatory repudiation as a material breach and pursue a remedy then. So therefore, you don't have to wait until she doesn't show up to sue. So once you've been notified you're not going to comply, the other party can take action. Repudiation may be retracted, but again, that's up to Linda as to whether she would accept it. Having no retraction if the non-breaching party has materially changed their position, which I think, Linda, you've done when you've hired Angela. Angela, do you see that? No. Talini, I hope you come to the wedding. Okay. Although, Taylor, does it really matter? Everybody's looking at the bride anyway. So. Remedies of the seller. This is what the seller can do, and then we'll talk about what the buyer can do. The buyer is in breach. Seller has various remedies. Some of the things to think about in the remedies is who has possession of the goods, whether the goods are in transit, and whether they are conforming or have been rejected. Goods in possession, you've got the right to cancel or to rescind the contract. But Taylor, you must notify the buyer, and the buyer is discharged from remaining obligations because of the notification. You've got the right to withhold delivery. If the material breach by the buyer, seller can withhold delivery of all goods. If non-material breach, seller can withhold delivery of this installment until the cure. Seller can withhold delivery of all goods if the buyer is insolvent. What do you think about that? Matt, does that make sense? Seller can withhold delivery of all goods if the buyer is insolvent. Later, when we talk about bankruptcy, we'll define what that means, but generally means that you're not able to pay your bills as they come due. And Candace, if my buyer was if you were the seller and the buyer was insolvent, you won't stop delivery because
Because you don't want to lose.
she might not pay you. If the goods are in possession of the seller, right to resell, dispose of the goods. Seller can resell and keep profits from the sale and hold buyer liable for the difference. So Candace, we'll see this again when we talk about debtor-creditor law. But yes, suppose that I seize the property. You owe me $1,000, and I seize the property and I sell it to